Kia ora koutou. I'm Michael Jamieson. I manage the Building Disputes Tribunal. It's great to have you all here for today's webinar, Getting Blood Out of a Stone, What Adjudication in the Building Disputes Tribunal Fixed Fee Scheme looks like. Just a quick overview of our organisation. The Building Disputes Tribunal has over 30 years experience in the avoidance, management and resolution of building and construction disputes, including experience with the Construction Contracts Act since its inception in 2002. The Tribunal was recognised and respected as the leading independent nationwide provider of specialist dispute resolution services to the building and construction industry. We are also an authorised nominating authority for the purposes of nominating adjudicators under the Act. As you may know, the Act was designed for exactly the situation that we're in now, with a downturn in the industry and cash flow being tighter than normal. The Act is a pay now, argue later regime intended to keep cash flowing through the industry and giving quick, cheap decisions without the delay and cost of court proceedings. Having said that, parties can appeal a decision to the courts, but in our experience, most don't. Less than 1% of adjudications are challenged. Paul and John will explain all about how this process works, how much it costs, how long it takes, and how to get started. Before I hand over to them, just a bit of housekeeping. Paul and John will present for approximately 45 minutes. We'll have 10 to 15 minutes for Q&A at the end. So if you have any questions, please ensure that you enter them into the team's Q&A. Please also note that this webinar is being recorded and will be made available next week when it will be sent to you by email. I'm delighted to welcome and introduce our presenters, Paul O'Brien and John Green. You will have read their bios, so you will have seen their wealth of experience and expertise. They are two of the country's leading practitioners in this area, and we're very fortunate to have them present to us today. Without further ado, I'll hand over to Paul and John to start their presentation. Welcome to both of you, and thank you.
Thanks, Michael, and welcome to everyone who has attended today. It's our pleasure to present on this topic, getting blood out of a stone. It's a very real issue, certainly in today's market, and as I say, we're delighted to be able to talk to you a little bit about it today. It just seems incredibly timely, given the problems that the sector is facing. In terms of the webinar itself, we'll talk about the payment regime, the adjudication process and timings, important considerations before commencing an adjudication, submissions, quantum, and costs and charging orders. I'll start off just with a very brief discussion about the payment regime. I know the webinar was directed to adjudication and the LVC scheme, but it's so important, I think, that we reflect on the payment regime itself, which, if complied with and undertaken properly, may well prevent a lot of disputes from arising. In terms of the Act itself, the Act is quite clear. It's designed to reform the law relating to construction contracts, and in particular, to facilitate regular and timely payments between parties to a construction contract and provide for the speedy resolution of disputes arising under a construction contract, and to provide remedies for the recovery of payments. Payment claims. Look, we're still seeing many cases coming through where adjudications are brought on the basis of default liability, which we'll get to in a second. What does that mean in practice? It means that the sector is not using the payment claim regime properly. They're not submitting invoices as payment claims. They're not responding to those payment claims with payment schedules. And by default, a debt has accrued and they become liable to pay the claimed amount. So just in very short order, payment claims, you'll find the requirements for payment claims in Section 20 of the Act. They need to be in writing, contain sufficient details to identify the contract, identify the work and the relevant period, state a claimed amount and the due date for payment, indicate the manner in which the payee calculated the claimed amount, and state that it is made under the Act. It also, a payment claim must be accompanied by Form 1. That's the document that explains to the recipient what they must do on receipt of a payment claim and the consequences if they do not. In response to a payment claim, it is wise, at least, to provide a payment schedule if you don't want to finish up paying the claimed amount. In short, a payment schedule must be in writing, must identify the payment claim to which it relates, and it must state a scheduled amount. That's the amount that you intend to pay. If the scheduled amount is less than the claimed amount, the payment schedule must indicate the manner in which the payer calculated the scheduled amount, the reasons for the difference between the scheduled amount and the claimed amount, and in a case where the difference is because the payer is withholding payment on any basis, the payer's reasons for withholding that payment. Absolutely important that that is done. If that does not happen, then the payer will become liable for paying the claimed amount. The relevant sections that you should refer to in the Act start at section 22. Couldn't be clearer. A payer becomes liable to pay the claimed amount on the due date for the payment to which the payment claim relates. If the payee serves a payment claim, so it's obviously got to be a valid payment claim, one that complies with section 20, within the time required by the relevant construction contract, or if the contract does not provide for the matter, within 20 working days after the payment claim is served. So 20 working days is the default period. Many contracts provide for different time periods. It's absolutely essential that a payer is across those obligations. There are consequences and serious consequences of not paying the claimed amount where no payment schedule is provided. The payer becomes liable to pay the claimed amount to the payee within the time, if the payment is not made within the time allowed. And the payee may recover from the payer as a debt due in any court the unpaid portion of any claimed amount and the actual and reasonable costs of recovery. And also the payee may serve a notice on the payer of their intention to suspend carrying out construction works under the contract. So the consequences to a payer are significant for failing to provide a payment schedule. And yet here we are 21 years now since the Act came into force, and we're still seeing adjudication claims brought on the basis of default liability. So someone hasn't provided, or it's alleged that they haven't provided a payment schedule in response to a payment claim. To be frank, that is madness now. And it's absolutely essential that you comply with those requirements. The same or similar consequences also apply if you provide a payment schedule but fail to pay the scheduled amount by the due date. I mean, you're welcome just to read through those or have a look at the Act. But look, the consequences are the same. If you issue a payment schedule and you indicate an amount, that a scheduled amount that you're going to pay, then you're obliged to pay that amount, or you'll finish up paying the difference. Right. Paul, would you like to talk about the adjudication process and timing? I'll hand the clicker over to you.
Thank you, John.
Thanks.
So, look, the process is set out in the Act, but we thought we'd just give you a sort of a brief overview here. The New Zealand Act's pretty broad in that any party can refer any dispute to adjudication. Starts with the notice. The notice requirements are set out in section 28. The tribunal very handily has a template to complete. If you choose not to follow the template, make sure you read section 28. There are some things that you must include. appointment of an adjudicator, the parties are free to agree the appointment of adjudicator. My experience is that when you're on the cusp of adjudication, the parties can't even agree what day of the week it is. They tend not to agree on anything. Apply to BDT. You must wait at least 2 days from service of the notice before you make your application. The adjudicator is required to issue a notice of acceptance, which the tribunal will do often on behalf of adjudicators. And then the claim must be submitted within 5 working days of the notice of acceptance. The response, the statutory time frame is 5 working days. That can be extended either by agreement of the parties, or if there's a compelling reason to extend, by the adjudicator. The claimant has a right to reply. That must be provided within 5 working days of the response. There is no discretion for the adjudicator to extend that time, though we do continually get asked. And look, similarly, the rejoinder is a 2 working day time frame, and no discretion to extend that time either. Following the rejoinder, the decision comes, but the decision is 20 working days from the date on which the response is received. There is some discretion for the adjudicator to extend that by up to 10 working days, but it must be within the 20 or 30 working day period. And then there is an ability to correct the determination, but it's within 2 working days of the date of the decision. The slip rule, it is limited. It's limited to errors in computation, typographical or clerical errors. It doesn't allow an adjudicator to change the determination, but remarkably, we get asked to do that quite regularly, particularly by the side that doesn't win. John, would you like to just talk about the LVC scheme?
Thanks, Paul. Yeah, look, that's a really a good introduction to the adjudication process in summary. Some many years ago, we developed what we referred to as a low value claim scheme, and it was designed to provide cost certainty for parties to what we loosely refer to as low value claims. You'll see by the value of those claims, they're not necessarily low at all, but by industry standards, they're relatively low. So as I say, the primary purpose was to provide cost certainty, and also to encourage parties to refer disputes to adjudication as soon as they arise during the course of the contract, if something can't be agreed on, whether it's an extension of time or a variation or whatever it might be, rather than banking them to the end of the project when everything simply gets out of hand and much more difficult to resolve. So the scheme is premised on the basis that a claimant can bring a claim in relation to 3 issues. There are also limits to the number of pages of documents that the parties can provide in support of the claim. The detail of all of this is set out on our website, but it was interesting when we first set up the LVC scheme, we only had from LVC 10 to LVC 50. The scheme itself proved so popular that we responded to demand from the sector to introduce an under $5,000 claim. And you might ask, how does that make commercial sense? Someone that's owed $5,000, it makes eminent sense. And on the basis that the adjudicator's fee is fixed at $1,500, and on the presumption that the parties pay half of that each on a simple factoring basis, if you had to pay $750 to recover $5,000, it makes sense. What we saw happening was that payers were, in some cases, deliberately deducting relatively modest amounts from contractors' accounts on the basis that it was assumed that it wasn't cost effective for contractors to pursue that amount, and they wouldn't. So what we've done is we've provided a mechanism that enables contractors to pursue those smaller amounts for sums that are proportionate to the amounts at issue, that are fixed, and they're welcome to avail themselves to this process. And it is something that is used regularly. Interestingly enough, a few years ago, we were approached by the Adjudication Association in the UK, who'd been researching globally what might be available to assist them to deal with these sorts of claims. We were delighted to work with them and agreed that they should essentially copy and adopt our LVC scheme, which is now available in a adapted form in the UK. So it is very successful, and it does provide cost certainty for the parties. Say the detail is on the website, and I invite you to look at that later. Okay, Paul.
Thank you. So look, some important considerations before commencing. Jurisdiction. In my own sphere, I do occasionally see jurisdictional challenges, and I know John probably sees a lot more of them than I do. But these might seem like simple things, but is there a construction contract? There's quite a broad definition of what is captured by the Act at Section 6. Have a look and just make sure. And very importantly, has the matter been dealt with before? If it has been dealt with before, it can't be dealt with again in the adjudication forum. So they're two very important things to consider before you start. Other things that I'd urge people to look at is service of documents. Has that been carried out correctly? That's often where people trip up. And unfortunately, if we don't have jurisdiction and you have paid as the claimant all of the fixed fee, to John's point, there's no ability to award costs because we don't have jurisdiction. So unfortunately, you're saddled with the whole thing. So be very, very careful and just urge a bit of caution. Do you really have a case? I challenge people to think about this long and hard. Just because you've written it on a piece of paper doesn't mean you necessarily have an entitlement. If you're chasing a determination on the merits rather than on a default liability basis, have you done the work? Is it really a variation? These are the sorts of things that you need to ask. My clicker. There you go. And do you need a lawyer? Not for the adjudicator or for the tribunal to advise. I guess my view is if it's a simple claim and it's related to simple matters that aren't really legal in nature, then probably not. And it's a good way to keep the cost of the process down. Submissions. As John said, look, one of the real good things about the way the low value schemes set up is there are limitations in what you could put in. I talk about limited page real estate. Use it wisely. If you have a limited number of pages, please don't waste 2 pages telling me what a wonderful business you have. That's very interesting, but it's not materially relevant to your dispute. So I kind of always say concise and to the point. Explain what you want and explain why you say you're entitled to it. Create a logical structure. It helps. And include uncontested factual background. Present the facts, present them chronologically, and if you can, support them. set out what the issues are, set out an analysis of the issues and what you believe the outcome should be, and if appropriate, apply the relevant law to the facts. In terms of how to structure it, we just thought we'd include like a sample writing structure. Said earlier, an introduction, a factual background, the issues, identify the factual and legal issues and questions to be answered. It's very difficult to, as we said, distinguish the relevant facts and arguments until you've determined precisely what questions you want the decision maker to answer. And unless issue is clearly separated, it becomes very, very difficult to actually come to a determination. Evidence. Look, I get quite passionate about evidence. Contemporaneous evidence goes a long way to demonstrating a case. The best example I can give is if you claim to have emailed somebody, give me the email. If you don't provide the email and the other side contests that the email's ever been sent and the email's not there, it's very difficult to come to any other conclusion than the email hasn't been sent. Make sure the information's relevant, though. Again, there's a limitation on what you can submit in terms of volume. So don't just throw everything and the kitchen sink in. And cross-reference well. If an adjudicator is struggling to understand your case because it's poorly laid out and your evidence isn't particularly well cross-referenced, it's very difficult for an adjudicator to find in your favour. And if there are specific areas, highlight them. Use of witness statements, if appropriate. There are, it said, limitations on the size of claim and the number of pages, but witness statements are a good way to include additional information. But again, keep them concise, keep them relevant. Witness statement isn't a place to set out what you think of the other side. That's not what they're there for. And as we've said, look, ultimately, make it easy for the adjudicator to understand your case. If we can understand, it makes finding a determination in your favour probably an awful lot easier. Quantum is an interesting area. Look, we've said, show me the money. Very often people will just simply put a number in. It makes it very, very difficult, particularly if it's a claim on any basis other than a default liability claim. Very difficult then to actually go in and work out what's entitled. You run the risk of me doing it for you. I'm a QS at heart and we're notoriously tight. Or worse still, you run the risk of me being unable to come up with a number. And again, support with evidence. Demonstrate an entitlement to be paid. It's kind of fundamental to the basis of the case. John, you were going to talk about interest.
Thanks, Paul. I'd really just like to, before I do that, just to reinforce what Paul has said. Going back to the question as to whether or not a party needs to be legally represented, we can't answer that for you. All that we'll ever say is that if you're unsure of your legal rights or obligations, then you should take independent legal advice. But in relation to the smaller claims, we also appreciate it is very difficult for lawyers to provide comprehensive legal services in support of these claims because they too, like us, want to provide a proportionate response to the problem, the amount of money. So what we say to a lot of parties to these cases is, you know the story better than anyone else. You set out what's happened and what it is that you're seeking and why you're seeking it, and put together the relevant documents. And then if you do find that you need advice or assistance from your lawyer, then you can give them those materials that they can review for you, which will be a lot easier than them preparing them from scratch. And they can also then include any legal submissions that might be relevant. That seems to be a sensible way of using that resource to its best avail. As Paul also mentioned, it's really important that the submissions that are presented are concise and logical and coherent. In so many cases, they are not. They wander around all over the place, referring to matters that are just not relevant to the matters at issue. As Paul said, you might be an incredible business person and the other person might be the biggest rat bag that ever walked the planet. But we really don't need to hear that, because it's going to make absolutely no difference to the answer. So do avoid the use of intemperate language. It doesn't help. It is really just a distraction. Focus on the key issues, just logically and clearly. And then where you disagree with something that the other side might have said, then you can take it apart with surgical precision. And also just reinforcing this, the question of quantum. There's two points always arise in relation to any claim: liability and quantum. So the decision maker, the adjudicator, is going to need to decide whether the other party is liable to pay the amount that has been claimed, or it could be some other amount. So it's absolutely essential that you set out how you have calculated the amount that has been claimed. It will inevitably involve multiple issues and multiple factors, including labour and materials. So if you don't get home on the whole of the amount, it makes it incredibly difficult for an adjudicator to figure it out. So we're quite serious when we say, give me the maths and demonstrate your entitlement to be paid. We then get on to the question of interest, detestable to God and man. The interest in interest has excited the passions for generations. Pope Sixtus V condemned it as detestable to God and man, damned by the sacred canons and contrary to Christian charity. I'm not sure whether the Pope was a developer or a contractor, but in any way he held a pretty firm view as to interest. So if you need to make a detestable claim, interest may be recoverable if there's an agreement or contractual entitlement as special damages under the second limb of Hadley and Baxendale, but you must provide proof of the loss suffered. If the contract provides a right to interest, you must comply with the contractual requirements to establish your claim. Some contracts will require you to provide a letter from a bank manager or a chartered accountant. These are older form contracts, but they're still in use now, certifying overdraft rates, etc., that would have been paid or payable. Sorry, I'll just go back one step. Likewise, if the contractual interest is based on 90-day bill rates or whatever it might be, then set out those rates and also set out the calculation of interest. In many cases, parties will just claim a lump sum as interest on the amount liable. When you look at these claims, many of the amounts that interest is claimed on became payable on various dates in the past. So the interest is not payable, obviously, on the entire amount for the entire period. So we need to know the amounts, the periods, and the rates. And it's really helpful to an adjudicator to receive a copy of the spreadsheet calculation that hopefully someone has used to come up with a figure for interest. So, as I say, if you're going to claim interest, there are some steps that you need to climb over, but make sure that you do that well. So that's what we say. If you're going to make a a charitable claim for interest in the Pope's terms, then interest will generally be calculated on the GST exclusive amounts claimed. It may change in the context of residential construction contracts, but by and large, most contractors are GST registered and GST is excluded. So as I say, please provide the calculations showing the rates, the uplift. In some cases, construction contracts provide for an uplift in a particular rate. Quite often it's 50%, and set out the dates and the periods and the compounding effect and the totals. Give me the spreadsheet. GST, another tricky one, Paul.
Yes. John sort of touched on it there. Interest will be calculated on GST exclusive figures, but whether you decide to go inclusive or exclusive, just make it clear, please, and be consistent throughout. It's quite unnerving when you see a claim and the value that's in dispute changes right throughout. Takes me a wee while to work out that it's actually 15% and it's GST that's not being applied consistently. Costs and charging orders. This is kind of always an interesting area. Two types of costs. You have the parties' costs and the adjudicator's costs. The Act deals with both. As an adjudicator, you have very limited discretion to award costs against either party. In terms of the parties' costs, can only do this where there have been one of the parties has acted in bad faith, or there have been allegations or objections without substantial merit. Interestingly, any pre-agreement as to the apportionment of costs or an indemnity is specifically unenforceable. Section 56 of the Act provides that you can't have that. In terms of adjudicators' costs, again, only two grounds in which you can move away from the default provision of an equal share. That is where claims or allegations are made without substantial merit, or a party has acted in a contemptuous or improper manner. In fairness, look, doesn't happen often, but does happen. I think the fixed fee scheme we talked about earlier, which brings us to the magical world of charging orders. Charging orders, very powerful. Essentially gives you the ability to register a legal interest over somebody's property, as a result of which must follow the process correctly. If you fail to follow the process correctly, an adjudicator cannot award a charging order. You have to identify that you are seeking a charging order in the notice. You also have to identify the property. This is one area where I would suggest that legal advice is probably merited in order to be able to get proper copies of the land registry documents so that you are sure you have identified the right property. If you haven't, or you're not sure, and I'm not sure, I can't give you a charging order. You can imagine what an absolute travesty it would be if I granted you a charging order on somebody else's property. That just wouldn't be appropriate. And one of the other issues, or one of the other little nuances of the Act, in order to get a charging order, the adjudicator must be nominated by an authorised nominating authority. So if the parties agree to an adjudicator, you do not have the ability to seek a charging order. There are some restrictions. Charging orders aren't available against family homes. The site must be owned by the respondent or by an associate of the respondent, and the Act sets out in a little bit of detail what an associate of the respondent looks like. But if you're successful and you have applied for a charging order and the respondent is the owner, mandatory the adjudicator must award the charging order. Slightly different if the respondent is not the owner, in which case you must show that the associate is jointly and severally liable for any award. Adjudicator grants you permission to seek a charging order, but to get the charging order on the property, you have to go and get that enforced at court.
Paul, that's a really important point. Yeah, the adjudicator doesn't grant the charging order. The adjudicator simply grants consent for the issue of a charging order. If the charging order is sought against the owner of the construction site who is not the respondent, and just going way back to the start of our presentation, it's important that that person is served a copy of the notice and they are joined to the proceeding as the owner. So they have the right to participate in the adjudication proceeding and argue obviously their status and liability. So yes, if the land is owned by someone other than the respondent, first of all, they need to be an associate of the respondent as defined in the Act, and then they need to be joined as a party to the proceeding from the beginning. So, but a very, very powerful tool and quite capable of bringing a construction project to its knees, including all the funding arrangements. So yes, it makes a big difference. So thank you. I mean, that pretty much brings us to the end, Michael, of
Yes.
the topics that we intended to copy to discuss today in relative summary form.
Yes.
All of those topics are capable of a discussion on their own.
Yes.
For a much longer period of time, but
Yes.
all of the information that we have shared with you today is available on the Building Disputes Tribunal website. It is a comprehensive website. We know that it is accessed, by people interested in adjudication and other matters locally, but also globally. And a number of universities overseas have links to the website for information that we put up there because it is comprehensive and detailed. You'll also find on the website, as Paul mentioned before, templates for every step in the payment and adjudication process that you're welcome to use or adapt and adopt for your own means. But if you're going to fiddle with them, then please make sure that they comply with the Act. There's really no need to fiddle with them unless you're desperately minded to do so. So all of those templates are available and accessible 24/7. There are also a series of guides and practice notes concerning every step of the payment and adjudication process, from payment claim to enforcement and objecting to enforcement later on. So as I say, a wealth of information that's available. So Michael, that really brings us to the end. I know we're a little bit quicker than we
we are a little bit ahead
we
of
may
time.
have raced through.
We do have time for questions if anyone's got any questions they want to put into the Q&A section of the Teams meeting. I just had one question that our registrars get asked quite often, and that's what's the benefit of going through the adjudication process rather than just going through sort of debt collection proceedings?
That is a good point, and it's one that is often raised, and in particular in the context of default liability.
Yes.
Almost invariably, if a party claims payment through a debt collection agency, they'll be met with an argument that there's a dispute about the amount claimed, so that there is no liability, there is no debt, and in most cases they'll say, and in fact the other side owes us money. So that's not a helpful start, and they're unable to enforce. The smart money is on getting an adjudicator's determination that establishes entitlement to the money, and then enforcing that determination if you have to.
Yes.
Saw an example of exactly what you're talking about literally a couple of days ago, where a contractor was owed a sum of money, threatened a stat demand, etc. That was met by another lawyer's letter raising objections and denying liability for the amount. Likewise, if they had proceeded to issue those stat demand proceedings, they would inevitably have been met with an argument that there is a dispute. The matter would then be referred to the general list.
Yes.
You could be in the court system for a very, very long time now. So this way, even if it is default liability, because a claim for default liability will often be resisted by an argument that either the payment claim was invalid in the first place, or that there was in fact a valid payment schedule, until a court or someone else, an adjudicator, can determine what the actual situation is. Then no liability has been proven. So in either case, whether it's merits or default liability, as I say, the smart money is on getting an adjudicator's determination, establishing liability and entitlement, and then enforcing that if you have to.
Yes. Yeah. Great. Thank you very much.
And I've always summary judgment has a 15 working day period. If you had a smooth sailing adjudication, you can have a determination in 30 working days, twice as long. But as you say, if a summary judgment is contested, you want to join the general list. Good luck.
Yes. Yes. Thank you very much. Well, that brings us to the end of the webinar today. As I said before, the recording of the webinar will be sent to you next week, and you're welcome to reach out if you've got any questions through the contact details on our website. I hope you gained some useful insights and information from today's webinar. The sort of key takeouts for me were the discussion on the payment claims and payment schedule regime and the need for strict compliance with the Act and the forms. The process and timing, as we've just talked about, the sort of at the most will be around 6 weeks, 45 working days, and as Paul said, can be shorter than that if everyone's efficient. And the cost certainty around the LVC scheme. Just in the last week, we've had an LVC 5 for a claim of $4,500 and a general claim for over $2 million. So we know there's demand for LVCs as well as for the larger claims out there, and we're keen to help people resolve those disputes. So thank you very much to Paul and John for an excellent presentation. Thank you all for joining, and we look forward to running another webinar for you all soon. Thank you.
Thanks, Michael.